and we proceed to our last speaker in this part of the event, which is Joshua Franco. Joshua, who is with Amnesty Tech, is a senior research advisor working in topics such as digital surveillance and censorship, AI, and also online violence against women in countries including Belarus, Uzbekistan, Azerbaijan, and elsewhere. Joshua will be talking about some very basic issues, I believe. Human rights online. Where are we, and where will pandemic response take us? Joshua.
Hi, thanks for that intro. I'm happy to be here. As Eric said, I represent Amnesty International, specifically Amnesty Tech. I'm just going to pull up my slides here. So I'm going to talk about surveillance, human rights, and pandemic response for a minute. In light of the time that I've been asked to limit myself to, I'm just going to limit myself to talking about the last few decades in terms of human rights development and everything that goes along with it and societal ramifications. So if I run over, please do yell. So basically, Amnesty Tech, where I work, is this lovable group of misfits pictured here in our band photo from our retreat last year. Basically, we are a multidisciplinary global team of technologists, investigators. Myself, I'm a lawyer by training, media professionals, hackers, and others based globally in many different locations who work on the human rights implications of tech. So my talk now, I misinterpreted some of the talk topics in the program, but I want to go very big picture and not really spend a ton of time on some of the questions around contact tracing apps and other things, which people have covered very well already, but to really sort of pull out and talk about where we are in terms of societal questions and human rights questions that I think this pandemic raises. And I think one of the questions that you hear, at least in my world, around the current moment is whether this is sort of another 9/11 moment. And I think what people mean by that is, you know, are we going to see the types of repressive surveillance programs rolled out that we saw under the Patriot Act and things like that after 9/11 now? And I don't think that that's entirely misplaced. I just grabbed this headline in the slide from yesterday about enhancements being made to the, or depends on your point of view, enhancements to the Patriot Act. So I think that's not entirely misplaced, but I want to suggest a different framework. In this talk, I think 2013 might be a better moment to measure against. And for me, the question is, are we in another post-Snowden moment? And if so, what have we learned since then in human rights terms? And how should that inform the debate going forward? So I want to focus on three sort of key things that I've noticed in the last 5-6 years working on this issue, which is how long I've been working on this issue. A couple of things that emerged post-Snowden, I think, as we were reacting to the revelations about mass surveillance. One is privacy fatigue. And I call this sort of the problem of the jaded adult, or just in general, the of course objection. Like, well, of course the NSA is spying on you, grow up. So that sort of privacy fatigue is something that we're up against constantly in this battle. In a way, I think that's the biggest question that we've not yet answered. The second thing I want to talk about is many groups who work on privacy issues, and not all by far. There were many groups doing this long before we got involved as well, which deserve credit for this. But there was a lot of emphasis on state surveillance, understandably, given what had been revealed, that tended to hive off the surveillance practiced either in whole or in part by private companies. And I think that's a mistake. And I also think it's a distinction without much difference at this point, which I'll go into later. And third, and this one really bugs me, in the initial reaction to the surveillance revelations that Snowden gave, we had spent a lot of time debating a framing put forward mostly by states about what surveillance is and when it matters. So is this a privacy question? And basically the framework put forward, as many of you will recall, was, listen, surveillance means a human being reading the content of your email. If it's only the metadata, if it's only a machine looking at it, this isn't surveillance. And I think we lost far too much time debating that point, because we now understand much more about what metadata can do. And it's very relevant to what's going on. And of course, there were warnings along the way that this was the case that we perhaps should have picked up on. So I'll take these issues slightly in turn just as a framing thing. I forgot to check what time I started, but surveillance, what is it? what have we come to understand? So basically, thing one, it's more than privacy. I think we all can understand that the impacts of unlawful surveillance go well beyond that. And here you'll see a couple victims of targeted surveillance, which include Ahmed Mansour, a human rights defender in the United Arab Emirates, as well as Amnesty International, where I work, where a staff member was targeted with NSO software, the Israeli surveillance vendor. But the other picture up here has to do with research that we undertook at the beginning of that period, looking at what are the chilling effects caused by surveillance. And chilling effects are one of those phrases that gets thrown around a lot in the surveillance debate, which doesn't have a ton of impact in my experience. It's hard to convince the unconvinced on this one. And so what we're trying to do here is really unpack the practical implications of a chilling effect. What does it look like for civil society activists, independent journalists, lawyers, opposition people, working in an unlawful surveillance environment like Belarus? And what we found was the chilling effect can be not only quite practical, but and mundane, but also really damning, that it has the effect of driving civil society out of the conversations that they need to be part of through making it impossible to have a conversation safely in your home, on email, on the phone, or even in person, because phones, as we all know, can track you, hence the apps. But this really tells us more about what privacy is and what it isn't, and the extent of the human rights implications of living under unlawful surveillance. And obviously I could say a lot more on that, but moving on the metadata point, we now understand that the surveillance at issue and other uses of big data can be tremendously harmful to a range of rights, most notably discrimination, but really all rights. And you'll see here, we've spent a lot of time in the tech and human rights community speaking about predictive policing and the potential disparate impacts and discrimination in policing that can cause. That is the graphic on what I believe is your right, stage right there. A PredPol study from the Human Rights Data Analysis Group in Berkeley, where I believe Edward is, my old alma mater, go Bears. And I also just want to bring attention to the more pernicious effects of big data generally, and what can happen when data is shared across government apartments. We spent a lot of time looking at both theoretical and real risks of this. One is our study of the gang's matrix, which is a database, quite simple one that doesn't involve much analytics, in the UK, which has discriminatory impacts on young Black men and boys who are suspected of gang involvement. And how that works is that the data then is used in what the Information Commissioner's Office, the Data Protection Authority here in London, in the UK, referred to as the Al Capone approach. In other words, if we suspect someone is a gang member, we, the police, suspect someone is a gang member but can't prove it, go after them for something else: tax evasion, housing, school, immigration. So those sorts of harms illustrate how different people's rights are impacted depending on who they are and what their relationship with the authorities is. And on the public-private point, I just want to make the obvious point that Edward Snowden, when he leaked all this detailed information about what the government was doing, was not actually a government employee. He was a private contractor at Booz Allen Hamilton, which ought to have raised some flags, I think, for many people about what this company was doing in the heart of our intelligence apparatus. But I think now we understand a lot more, and here I will mention surveillance capitalism in terms of the business model of the surveillance-based internet and what that means. At Amnesty, we published a report on this issue, what we refer to as surveillance giants and the human rights risk inherent in the Silicon Valley business model, but also in other ways that are perhaps less well known. I have a slide up here from In-Q-Tel, which, as some people may know, is the CIA-backed venture capital firm in Silicon Valley, which has helped numerous firms. And there's extensive mixing between the national security state and a lot of private companies that really makes that distinction, I think, hard to maintain. So all of this is sort of background to where we are now. And I've mentioned it because I think that as we understand the full risk of harms that surveillance can bring, we need to think more carefully about the impacts and potential impacts of the moment we're in. So a lot of speakers have gone over the emerging trends here, including contact tracing apps, predictive analytics, public-private partnerships, and other types of mobility tracking, which are far more limiting than the ones that we've seen described here, things that can actually be used to alert the authorities if you're making some sort of unlawful movement, attempting to leave your house, etc. So what I really want to stress about these apps is that there is a large discussion going on now about the trade-off between privacy and health. I think as Walter, I believe, was emphasizing, that trade-off is not inevitable. If you design with privacy in mind, it can be largely avoided. But I also want to emphasize that human rights law speaks exactly to this. Human rights law is not absolute. Rights can be limited in the pursuit of legitimate aims, and in severe emergencies, not unlike what we're in now, many allow for derogation, which is a more severe form of limitation. But it's not without rules. It was specifically designed, I mean, human rights law was codified in many ways post-World War II to guard against the types of severe upheavals and abuses that we saw in that period. So basically, thinking about the framing that we've seen of the harms and what human rights law says about that, the basic idea for limitations of rights in the legal sense has to do with, first, there must be a legal basis. Second of all, you must meet a legitimate aim, which public health is one. And then the conversation tends to shift to necessity and proportionality. And I think this is a thing I want to spend a minute on. If I've still got one, I think I do. Because they're often conflated and in ways that I think make the debate difficult to understand. So the cops and robber graphic here, which I took from Creative Commons, is meant to illustrate this point. So let's step out of the tech realm, and apologies for the simplicity of this metaphor, but I know the room's not full of lawyers necessarily. So in this analogy, you've got a cop chasing a suspected thief, a suspected shoplifter. The shoplifter is so far away that literally the only way the police officer can capture this person is by shooting them dead. In that sense, shooting this person is necessary. It is the only way to achieve the legitimate goal, but it's not proportionate. It was never proportionate to shoot a suspected shoplifter based on that suspicion. So these two things are different, and I think that difference is important as we discuss this. Why? Because I think there is a tendency to jump over one or the other, or to conflate the two. In the pandemic response situation, in terms of privacy trade-offs, we're often asking questions about what can be done. So we have safeguards that we'd like to see as Amnesty reflected in a lot of the apps that are being constructed that I think many panelists share, which deal with questions of, say, we don't want a centralized database, we prefer a decentralized approach. Okay, that's great. But then you get into a debate about proportionality. If we can't do X, can we do Y, which is a little less invasive, and it skips necessity. And necessity is important here, because if an app is not effective, it can't be necessary. So before we begin debating the limitations that we might envision, the limitations we might allow, first, let's make sure that what we're doing this actually brings a benefit, because I think the harms could be quite large. And the reason I spent the time talking about Belarus and discrimination and machine learning and all the rest of it at the outset is that in necessity and proportionality, you've got to weigh the harms. And I think it's important that the two sides of the scale reflect evenly what's at stake. We know what's at stake on the one side, but I think the human rights picture needs further fleshing out. So I'm going to see what I can skip here. Where are we getting into? I love this quote by Paul Virilio: when you invent the airplane, you also invent the plane crash. We're seeing a lot of new tech rolling out. We're seeing new developments, and we don't know exactly what sorts of plane crashes we're going to see in the future with these new developments, but we know certain things. We know who's flying the plane, and we know how they've behaved in the past, and that should give us pause. We know that surveillance technology is abused routinely around the world. You need only look in the headlines to see dissidents being targeted, rights being rolled back, people being jailed for tweets and online posts and things of that nature. So I think while we can't know what will happen, it would be naive to close our eyes to the very real potential for abuse that new surveillance tech is going to entail around the world. And I think when we think of that, oops, getting ahead of ourselves there. I think of that, we've got to think about privacy in the holistic sense, because we are not just talking about the embarrassing web pages we visited, the picture we shared, but we're talking also about the Uzbekistani exile who has not contacted her family in many years out of fear that phone surveillance will get them in trouble for getting a call from abroad. We're not thinking about the student activist in Belarus who's threatened through the interception of his personal messages with his sexuality being outed if he does not stop protesting. But these are all things that need to go on one side of the equation, and harms that we ought to anticipate, similar to harms we ought to anticipate coming down the line. So a couple of things have changed. As the last panelist, Amy, was talking about, we're in lockdown. Most of the world is in lockdown. Many countries are starting to leave, but everything we do now is online. And one of the things that came up in the Belarus context that activists would say is often that you have to, in order to really ensure privacy, go for a walk somewhere private without your phone. How do you do that? We have to arrange it the same way. So it's quite circular, and this is how the chilling effect plays out. But if we have mobility tracking, ubiquitous mobility tracking, there's a very real possibility that last window could shut as well. So that's kind of a nightmare scenario. Will it happen? Of course, we don't know, but we know the tendency to abuse tech, so it's worth to being alive to. The other thing we know is that it's bigger than privacy. We know there these contact tracing apps and other types of health apps that we're seeing, location tracking apps that were being rolled out, don't necessarily work equally in all situations. And that's going to have different implications for the right to health and whether it's ensured equally if you live in a crowded urban environment versus a very isolated rural environment. You're going to have different rates of false positives and false negatives, which could have different implications for how long you're asked or told to stay home, whether you're allowed to work, whether you're expected to work, and questions of that sort. And the last question really on sort of privacy fatigue is one that I think I'm going to come back to at the end and really suggest how we do this. So basically in the COVID, oh my God, I have too many chat platforms. It's the modern world. We're all online all the time. And what I would like to say is that the proportionality argument, when we look at that as lawyers, usually involves questions about what are the safeguards. One way we can know whether a restriction is proportionate is say, is the surveillance legislation transparent? Do people have a way of knowing what to expect, when they might be surveilled, when they might not be? Will they have access to information about whether they were in future? Are there courts overseeing the warrants? Are there oversight mechanisms? Things like this. And I think now is a good time to take stock of what those protective mechanisms are. And we've spoken about data protection already, but it's very important to remember that GDPR is not a global regulation. And even within it, of course, there's a lively debate about the efficacy of data protection in the human rights context and whether it is in fact adequate. What are the role of national security and law enforcement exceptions in GDPR? And what is going to happen in countries that lack a state level or a national level privacy regulation like the US? And the other and of course, there's the recent study by the Brave looking at the really systematic underfunding of data protection agencies and how that impacts on the ability to regulate data protection. Other remedies out there that we have attempted to engage include courts and other regulatory mechanisms. Courts have been a mixed bag over the years. The headline here about Amnesty versus Clapper, which sadly is a precedent that bears our name, had to do with standing and whether you could even sue a surveillance program in court if you did not have proof that you were literally a target of surveillance, which of course is a sort of catch-22. And then the illustration here on the left is a map of Hacking Team and Finn Fisher exports. For those of you who paid attention, you'll know this story very well. It was a few years ago, but in essence, these were European companies selling spyware to governments all over the world, and we eventually found out who. And what we've learned since then is that there are very few safeguards in terms of the exports of surveillance tech from Europe or most other places to look at who the end user will be and how that's impacted. So, I mean, quickly summing up there, the safeguards that we would look to ensure proportionality of some of the potential harms that we're looking at from increased data protection are not necessarily going to protect us comprehensively. So I've now shifted windows, so I can't do this. There we go. So these risks that we're facing, increased tracking of personal data through phones, which may or may not be shared across agencies, which may or may not be shared within private partnerships, public-private partnerships, where we see companies who have problematic human rights records in other contexts now stepping up to help with COVID response. It's sort of up to us. And I would argue that part of the reason here, and this is not a sort of human rights argument, but rather just an intuition in my personal opinion, is there's a saying in English, when all you have is a hammer, everything looks like a nail. And I think part of the reason that states and others will find it tempting to reach for many big data solutions to the COVID crisis, not that they all will fail, but some will, is because that's readily available, because that's the internet we have, because ubiquitous surveillance is the bread and butter of the entire Silicon Valley business model, more or less. So the internet, as legend goes, was created to withstand a nuclear attack, hence the packets. But I think coming out of this, we need to seize the moment to really talk more about the societal implications of what ubiquitous surveillance does beyond privacy, looking at discrimination, equality, the right to health, economic rights, development, and all the rest. And we need to build an internet that will withstand a pandemic or the next emergency. And I think if we have a privacy designed system, if we have a better privacy respecting framework to work with from the start, we'll be in a better position for the next emergency. Thank you.
Thank you very much, Josh. Very complex topic with many different subtopics that would emerge. I'd like to ask one question quickly, simply because it's kind of included in your title. And that is, I mean, human rights are human rights, aren't they? I mean, they should be, well, maybe not completely absolute, but at least for a given time and a given societal development status, they are human rights. But what's your opinion about the relation between the digital and human rights? I mean, is the digital world a complete game changer for the nature of human rights, or is it just that we need different implementation schemes, different instruments? So I'm trying to frame this less of a yes/no, but a qualitative question. So to what degree does the digital impact on human rights?
Oh. Yes, I agree with your premise. I mean, human rights law evolves along with other new technologies to tech as well. And I mean, I think we've seen various iterations of this over time, but obviously not all of the human rights risks that we were seeing in the 40s or prior to that in other iterations of human rights standards or other things were not on people's minds, obviously, when this was written, but it's framed in terms of general principles. And I agree with you that human rights are absolute in the sense that they can't be taken away. They are, by nature, they inhere as humans when we show up and claim them, or even if we don't. But there are situations in which the broad concept needs sort of further elaboration. So if we look at, say, the right to free expression, we all agree this is a fundamental right, important. We also allow for things such as defamation lawsuits. We also allow for things such as laws against threat or physical violence or something like this. So it's ensuring that there cannot be an absolutist framework for all things. But I think the framework that it accepts in terms of legality, necessity, proportionality, and legitimate aim is one that should guide us in understanding that specifically when we face a crisis, we don't throw human rights law out the window. We have to undertake this analysis to understand what exactly it allows, because it was designed to help us in crisis, if that answers the question.
Thank you. I think we had another question from Andrea.
Yes. Thank you for a very interesting talk. Mine is going to be a little bit a provocative question.
Please.
But so as a scientist, it's very difficult to imagine to make, you know, new discovery by planning exactly which data we're going to collect, right? So a lot of unexpected discovery are done by data that have been collected for different reasons, which were not planned in the first place. So my question is about data collection versus analysis of the data. And I will claim that why do we need put any restriction on data collection? What we should restrict is how data are used. So I wonder if you can elaborate on this point and this difference, because often when we do data collection, we think the data can give, you know, very negative outcome that we didn't predict, but we never discussed that data collected can also give amazing result, which we didn't expect. But that's really depends on having the data in the first place.
Yeah, excellent point. And that's, I mean, it echoes a lot of the debates that I was alluding to, which are beyond debates. I mean, it's the subject of litigation in several countries around this question of where does surveillance start? And the argument about collection as the place where privacy begins takes it from European Court of Justice opinion on this, basically making the point that when we think of a state actor in particular, that was the context of that case, once you know as a private individual in society that your data is being collected in bulk, that there is potentially this dossier on you that, as we've heard in previous talks, as we were hearing Amy speak about from the home learning, sorry, I have children, from the home working environment, and the rest of it is that you know, you can't put the toothpaste back in the tube, and that in and of itself is where people start to question the way they express themselves. And again, this self-censorship issue is one of the key harms that we see in surveillance. So while it is easily dismissed by those who are not convinced as something that is an individual choice or as the result of sort of an unreasonable fear, we have to look at where that comes from and what exactly is reasonable to fear in terms of the conclusions that can be drawn from your data, the places the data can be shared onward, the things that the analysis can yield, the profiles as Clara was indicating that can be built on us. So all of those things are potential harms. And in the absence of other safeguards, they become even more damning. I mean, so where you have a state that does not respect judicial oversight for warrants of surveillance and things of this, that's going to be even more daunting. On some levels, of course, you know, the technology is built in such a way that, say, the GCHQs or the NSAs of the world, when they were engaging in, say, cable tapping exercises, you know, this is not something that lends itself to a discriminating human eye on what is relevant and what is not, which is part of the problem. It's the methodology itself. But I don't mean to suggest that scientific research falls under the same bag as government surveillance, but nonetheless, a lot of those risks that inhere from state actors do inhere private actors as well, if safeguards aren't respected, which I think is the point of having them, to say that. So I'm not in any way ruling out data analysis per se, merely warning of the harms if safeguards aren't adhered to. Is that getting at your question?
Mm-hmm. Okay, thank you.
Thank you so much, Joshua.
Thank you for having me.
There were two more comments. I'll just read them out. There was one by Johnny Golding saying that collection of data has been part of the Nuremberg Code since World War II. It matters ethically how collection takes place. And there was one comment by Magdalena Czacaki saying that how could these ideas influence technology developers? I think that is probably the question that goes to each and every presentation that we've heard so far today. And this is indeed what we're trying to achieve in part with this digital humanism project. And I think at this point, I'd like to hand over to Hannes simply because of time. And then I let Hannes decide if we have another round of questions or whether we proceed. Hannes?